So it's somehow related to this question of retrospectivity and and presumption regarding prospectivity in application or operation of statutes. So from now on, we are going to discuss about certain presumptions. So the first presumption that we are going to take up is that of prospective application of operation of statutes. So does that mean that there cannot be any statute which is retrospective in its operation? Well, that's not the case. Okay, so because there is a sovereignty in the parliament. Okay, so that means that parliament can do, or for that matter, generally you can say that the legislature can enact whatever it wants to. Obviously, subject to other restrictions, but those are different questions. Okay, that there are certain constitutional restrictions that can be imposed. There is this question of rule of law. All those questions are definitely there. And the idea of rule of law also requires that statutes are prospective in their operation. That statutes are enacted, laws are enacted, which are prospective in their application. The reason is that I should know the law that is going to affect my conduct. Okay, so if I have done something previously, later on a law is enacted, it should not then make me liable for what I have done before the law was enacted. Apart from that, another idea is that if you have rights, okay, already acquired under the law, subsequently the assumption would be that it will not be taken away from you, by virtue of retrospective application of the operation of the law. So that's a presumption that we have, okay. But that in no way means that legislature cannot enact a law so as to, which is retrospectively not applicable. Okay, so what I mean is that legislature can, if it intends to make laws, it has the power to make laws which are retrospective in nature. So in India, the Union Parliament as well as state legislatures have the power of legislation within the fields assigned to them. So that's jurisdictional competency and subject to constitutional and judicially recognized restrictions. So that's there, but if the matter falls within its competency, then it can enact law, which can also be retrospective in nature. So there is no such restriction if you take a positivist approach here. So yes, however, okay, when it does so, the requirement is that it explicitly does so, okay, in unambiguous terms and in a very explicit manner, it does so. Okay, so it can enact retrospective legislation. So the legislature may make law which is operative for a limited period prior to the date of its coming into force and is not operative either on that or in the future. So it can in fact do so. There is no theoretical, obviously in theoretical there could be philosophical constraints, okay, as I just told you. But even, for example, from Fuller's perspective, okay, if you remember his idea of internal morality, even in his philosophy, he says that if there is constant, deviation from these, principles, okay, from those 8 desideratas, only then. So it is quite possible that legal systems now and then, might require laws which are retrospective in their operation. Only when they are consistent, consistent in making retrospective laws, then it would definitely raise questions. Okay, but basic assumption is that it can do so. So yes, it can amend the law, okay, and when amending the law, it can retrospectively change the meaning of a particular provision of law as was already in existence. So that's very much within the power, okay. However, as I told you, it has to be in very clear terms, okay. If it doesn't do so, so courts will not merely by implication. Obviously, it could be by implication, but only when it is clear, okay. Other than that, the assumption on the part of the court would be that no, statutes are prospective in their operation. So if 2 interpretations are possible, one that is prospective, other, that is retrospective, then the assumption would be that judges are to go with the prospective operation. Another implication of that would be that if there are two interpretations, one that says that it is retrospectively applicable but in limited circumstances, the other one that is retrospectively applicable but in a much wider sense of the term, then the implication would be that, then the assumption would be that the restricted sense is the one that is applicable. So that's the idea, okay, that it is the assumption that the legislature is just, that it is fair, that it is mindful of this idea of rule of law. So that's with that assumption, with that in mind, the judges then presume that legislations, that is statutes, are prospective in their application. So yes, the idea when it comes to the substantive rights, okay, legislations create substantive rights, okay, it may take it away as well, but it can create prospectively, it can also take away prospectively, okay, that's definitely there, okay. But retrospectively, something that you already had, retrospectively, when they are taken away retrospectively, that's when the problems arise, okay. So there's this idea that vested rights are not taken away without express words or necessary implication or without compensation. So that's the idea, that if your vested rights are taken away retrospectively, okay, they have to be taken away with express words, okay, and the implication has to be necessary implication. So there is no other way, okay, so it has to be necessary implication. And if your rights taken away, and one assumption is, one way of going with the interpretation would be that it is without compensation, the other is that it is with compensation, then the broad liberal idea would be that, well, it is taken away, then it must be with compensation. So you see, it's based on certain concept of right, okay, the liberal concept of right is definitely there. So the maxim says, nemo potest mutare concilium sum in ulterius injuriam. I'll just type it here so that you guys are not confused. So it says, nemo potest mutare concilium sum in ulterius injuriam. That is, no one is allowed to change his mind to the injury of others. The same applies even to the legislature. You had already given a right. Now, how could you take it away retrospectively? So it has to be, if it has to happen, then it has to happen through clear words or through necessary implication, or where it involves some loss. Okay, then definitely the liberal assumption would be that, well, there has to be compensation. So yes, if there are two interpretations, then these are the ones that the judges have to go ahead with. That's the assumption. So the idea is that as far as possible, law should be construed as prospective and not retrospective, except when they are expressly made applicable to past or pending transactions. So if a law is enacted today, we are to assume that it applies to what happens henceforth, okay? What about something that is pending? Okay, we are going to discuss that. And what about that which has already happened? Unless it is clearly expressed, the idea is that it is to be applicable to what happens henceforth. That's what the idea is. So in Maxwell, it has been said that a court will also not so construe a statute as to deprive persons of their properties and transfer them to others without payment of compensation, unless such a conclusion is ineluctible on account of policy or express words. Okay, so that's the idea. Even here, so the assumption lies, in default. So if the legislature wants to take away, then, well, that is very much allowed. But if that is not the case, then the assumption that, well, compensation is intended. Okay, so your right will not be taken away without providing you compensation. So that's the idea. Okay, so unless that is unavoidable, we are to come to the conclusion that yes, compensation is intended. Okay, so a case, an Australian property rights case is very important illustration to that. Okay, it's by the name Australia Commonwealth versus Hazeldale, yeah, in 1921. But keep in mind, it says that it can be taken away. But when it is taken away, the legislature has to be explicit about it. If that is not one of the necessary implications, and if it has not been explicitly been mentioned there, then the assumption has to be in favor of the property right of the party here. So in this particular case, by the name Australia Commonwealth versus Hazeldale, we are concerned with Crown Grant Act 1886. Okay, it is by the name Crown Grant of 1886. So under it, land was granted to the respondents. Okay, here, Hazeldale, land was granted to the respondents subject to reservation of minerals. And then in 1915, the appellant, that is the Australia Commonwealth, compulsorily acquired the land for the purpose of obtaining material for construction of buildings. Okay, so it was compulsorily acquired in 1915. So because it was compulsorily acquired, the respondent here claimed compensation. Now, in 1906, okay, much after the Crown Grant Act, by virtue of which the land was granted. So in 1906, the New South Wales Mining Act was enacted. Okay, so this act rendered the limestone in a bed under the land open to public mining. So that's there. Now it doesn't say anything about whether compensation is to be paid or not to be paid. Okay, it's not there. So if it is not there explicitly that it is being taken away without compensation, what is the assumption that is to be arrived at? So it was held in this particular case by the Privy Council, okay, that if the act were construed as throwing open to the public mining minerals granted by the Crown to private purchasers, the effect would be to alienate private rights without compensation. And it has been repeatedly held that such an intention should not be imputed to the legislature unless expressed in clear terms. Because of lack of presence of the same, that this compulsory taking is without compensation. Okay, because that's not there, that will not be assumed. So it will be assumed that it can be taken away, but subject to paying compensation. So the same idea, okay, that your rights will not be taken away retrospectively, and that would also mean that unless it is expressly mentioned, judges will not arrive at the conclusion that the taking here is without any compensation. So that's the idea, that's the presumption. So it's in another case versus by the name Re-Enthumni. So it's not versus, sorry, by the name Re-Enthumni. Enthumni. Just a second. You will find this in Maxwell. In Re-Enthumni, Justice R.S. Wright said, okay, that perhaps no rule of construction is more firmly established than this, that a retrospective operation is not to be given to a statute so as to impair an existing right or obligation. Okay, so if you have an existing right and obligation, unless that is clearly taken away, unless that is taken away by necessary implication, okay, that is not what the judges are to assume. Okay, so that's why it has been said that perhaps no rule of construction is more firmly established than this, that a retrospective operation is not to be given to a statute so as to impair an existing right or obligation, otherwise than as regards matter of procedure. So exception would be matter of procedure. Okay, so procedural law could also be retrospectively applicable. So even if your right has been created previously and some matters pending with respect to that, and it is procedural in nature, it may be applicable. But that is also critical. We have to look at that with a little more detail later. But the exception here is that of procedure. So otherwise then, as regards matter of procedure, unless that effect cannot be avoided without doing violence to the language of the enactment, if the enactment is expressed in language which is capable of either interpretation, it ought to be construed prospectively. So you clearly see that there is a liberal foundation to this presumption, that your rights, your liberties, your property will not be taken away, okay, unless that is explicit, okay. So even if there is a little bit of positive tone to it, but the underlying, idea is that it is protective of your rights, liberties, your properties. That's the idea here. Similarly, in our case, okay, by the name R versus Inhabitants of St. Mary, Whitechapel, 1848. So in this particular case, let's see whether the rule has been applied or not. Okay, so we are concerned with Section 2 of Poor Removal Act 1846. It's Section 2 of Poor Removal Act 1846. And what does it say? It says, no woman residing in any parish with her husband at the time of his death shall be removed. So creates an immunity. So shall not be removed if living with the husband at the time of his death from such parish for 12 calendar months next after his death, if she so long continue widow. So for 12 months since the death of the husband will not be removed from parish, okay, subject to if she continues being widow. So what if the husband died before this particular act was enacted? Okay, will the person be able to avail this benefit? So if she does, then the prima facie understanding would be it seems to be a case of retrospective application. But here's something that we are to keep in mind. The presumption against retrospectivity is when it amounts to taking away your rights, okay, or your property or liberty, okay, not when it benefits you, okay. So here, retrospective application in that sense would amount to her being denied that right, immunity as has been created under this act. Hence, Lord Denman decided that the statute is in its direct operation prospective. Okay, the benefit in its direct application is prospective. Okay, as it relates to future removals, and that it is not properly called a retrospective statute because a part of its action is drawn from time antecedent to its passing. So just because the incident had happened in its past, we are not to assume that the law will be retrospectively applied so as to deny that immunity to this widow. So it's not really properly to be called a retrospective statute. Okay, it provides a benefit, and hence in this particular case that immunity was given to this woman. So was this understandable? Does it make sense? Does this example make sense to you?
Yes, sir.
Okay. So yes, now the question arises, what about a law which is enacted, okay, right now, applies to certain actions, okay, but there were already pending actions, okay, under a previous law. So when the substantive law is altered during the pendency of an action, okay, the rights then of the parties are decided according to the law as it existed when the action was begun. So that's the idea, that no retrospective. It applies even to pending action, okay. Why is that? Well, the pending action had arisen when the previous law existed. So the same assumption applies even now, okay, unless the new statute shows a clear intention to vary such rights. So the same rule basically. So if it is clearly said that even the pending actions will be subject to this newly enacted law, okay, then obviously there is no other way. It has to be in accordance with what the law says. But in the absence of that, the idea is that even when it comes to pending actions, the previous law will be applicable. So you have a case by the name National Real Estate Finance Company Limited versus Hassan, 1939. Well, the outcome seems a little, problematic, but you see there is a clear application of this idea. Okay, so in this particular case, the landlord served a notice on a tenant under Section 146(1) of Law Property Act 1925, and accordingly, okay, in accordance with this act, okay, and subsequently issued a writ claiming possession of premises on the ground of want of repair. So this was allowed under the Law Property Act. So the procedure here, what has to be done here was laid down, and the landlord followed that. Subsequently, another act was enacted by the name Leasehold Property Repairs Act 1938. When it comes into operation, so it comes into operation with certain additional requirements. For example, now the requirement is that the landlord has to do the same with the leave of the court. Okay. Now the matter was already pending. Okay. This law came subsequently. So the question is whether requirements of this law will be applicable. So will the landlord have to also fulfill the requirements of this new law? So the Court of Appeal in this particular case held that the new act did not have retrospective operation, and it would not affect the rights which the landlord acquired by proceeding under the Law Property Act. That would have been the case had this law clearly said that it is applicable even to pending actions. That was not there, so the landlord would be bound only by the requirements of the Law Property Act. So yes, that's an example of the case of pending actions. Then another, so as I told you, that this idea of prospectivity, presumption of prospectivity applies, okay, unless it is clearly expressed or it is a necessary implication, or in case of property, the assumption is that there is unless that is the case, the assumption would be in favor of compensation. Okay, there was one more case, okay, situation when this assumption does not apply, and that would be in the case of procedural acts. Okay, now what are procedural acts? Acts that doesn't create, the provisions that do not create any substantive right in your favor. Okay, so we have to be careful here. Even something that is procedural in its appearance, okay, so for example, whether certain forum will be available or not, right of appeal, etc. So certain things might appear procedural, but if you look at it carefully, it really is a case of substantive right. So we have to be very careful with that. Now, apart from that, the idea is that when it comes to procedural acts, this presumption does not apply. So no person has a vested right in any course of procedure. Procedure could be whatever as is laid down by the law. Your concern would be your rights. Okay, it is not the procedure which is applied. So when it comes to procedural acts, this presumption does not apply. So in Gardner versus Lucas, 1878 case, in this particular case, it was said that alterations in the form of procedure are always retrospective, unless there is some good reason or other why they should not be. So the assumption is that, procedures are always retrospective. Okay, unless the matter is decided, then it's different. But if matter is there, okay, then the procedure would be retrospective here. So we have a case here that will explain the case. I will just mention the sequence of events, then I will read out the provision of the judgment. Okay, The case goes by the name Herridge versus Herridge 1965. Herridge versus Herridge 1965. So in this particular case, the parties here, they married in 1948. In August 1962, been a while, the wife left husband for cruelty. In the same year, on November 5, August, September, October, November 5, she returned to cohabit with him, which is alleged to be, because she returned to cohabit, that has been alleged to be a case of condonation. Okay, and again in December 4 the same year, she left for good for renewed cruelty. So the concerned provision for us here is Section 2.1 of Matrimonial Causes Act 1963, and later it was changed to Section 42.2 of the Matrimonial Causes Act. Okay, and it reads like this: adultery or cruelty shall not be deemed to have been condoned by reason only of a continuation or resumption of cohabitation, with a view to effecting reconciliation if it did not last more than 3 months. Now the question came later whether this would apply in this particular case, and whether this is procedural or not is also something that we have to look at. So the fact is like this, that the husband and wife were married in 1948, and she leaves in August 1962. For the reason, as I said, she resumes in cohabitation in November 1962, and again in December 4, 1962, she leaves. So in this particular case, okay, first, not the Court of Appeal, okay, the first court, okay, not the first court, whichever court it is, okay. So the President, okay, without referring to the said section, okay, as I read out to you, that is Section 2.1 of the Matrimonial Causes Act, and that came into force on July 1, 1963, okay, found that the husband had been guilty of cruelty, consisting of a course of conduct up to and including the incident of August 12, 1962. Okay. But that the cruelty had been condoned by wife in returning to cohabitation with him on November 5. So that's how it was understood. Well, she returned, so it has to be understood as condoning. So that the cruelty had been condoned by wife in returning to cohabitation with him on November 5. And the 2 acts of violence alleged by her to have occurred subsequently to her return did not amount to the conduct sufficient to revive it. Okay, because she came again, there's a break period. So yeah, so the President of the court dismissed the wife's petition. Then the wife appealed, okay, contending inter alia that the judge had erred in law in not taking into account Section 2.1 of the 1963 Act. Okay, the court held that, so this particular court held that Section 2.1 of the Act of 1963 was properly to be regarded as procedural section, dealing with what evidence might or might not be adduced. So this particular provision that we read out, okay, earlier, okay, adultery or cruelty shall not be deemed to have been condoned. Okay, had it been, if it was considered by the judge in the previous, by the President, okay, then the conclusion that it would have arrived at would have been different. But it didn't consider, okay, but the later court considered it as procedural. Okay, so this particular Section 2.1 of the Act of 1963 was properly to be regarded as a procedural section, dealing with what evidence might or might not be adduced in relation to an allegation of condonation in any trial taking place after the Act came into force. Okay, so even though that evidence might relate to events which took place before the Act, the section must therefore plainly be relevant to be considered in the present case. And insofar as the President had proceeded without giving it consideration, he had misdirected himself. So the Court of Appeal here considered that the said section of that is section 2(1) of the Matrimonial Clauses Act, which later became section 42 of another act, 1965 Act, was procedural in nature. Hence, the presumption would be that, well, it applies retrospectively. So even if that means considering a fact which was not considered under the previous law. So that's how this presumption applies. That is, when it comes to procedural law, there is no such presumption. However, here's something that you guys need to keep in mind. And that is that when it comes to right of appeal, okay, even though it seems that it is procedural in nature, the right in itself is not procedural. It's a substantive right that you have to appeal before a particular forum. Okay, so you will see that in certain cases the courts have wrongly come to the conclusion that, okay, that if by virtue of an act, a subsequent act, okay, for example, it changes the procedure, okay, the assumption would not be that, well, the right of appeal is also taken away, okay. Procedural change would not mean that your right of appeal is also taken away unless that is explicitly mentioned in the enactment, okay. So that's the idea. The same has happened in many different cases, okay. One important case would be by the name Radhakishan Lakshmi Narayan versus Sridhar, AIR 1950, Nagpur 177. I will just share it here. You will find it. But there are many other cases also where the same has been held. Okay, so this is the idea. There's another case by the name Lakshmi Narayan versus Shivlal Gurjar and others, 2002. This is also another case where the same has been reiterated. Okay, so when it comes to appeal, okay, although it seems to be procedural, is not really, because it's a substantive right created in your favor. Okay, so yes, that's what this presumption is all about. Okay, now one last thing, that is when it comes to declaratory statutes, okay, that basically exposits, okay, what the meaning of the law is. In that case, okay, this, the same is not applicable. Okay, so Maxwell says that the argument that statute is not to be construed so as to take away previously vested rights are inapplicable in declaratory statutes. So there's no such thing that by virtue of declaratory statute the parliament exposits or clarifies that, well, under the previous law your right did not exist. Okay, so there is no restriction against that. So Parliament is very much within its power by virtue of declaratory statutes to clarify what was the state of law earlier. That does not mean taking away your vested right. Its implication is that, but does not mean that your vested rights are taken away. So this particular presumption is not applicable when it comes to declaratory statutes. Maxwell says that. So I'll take one more small, presumption in continuation of this, and that would be enough for today. We will not have much left after this. So the next important, presumption is that legislature knows the existing law and does not intend to alter it except by express enactment. So when a legislation is enacted by the legislature, it is to be assumed that the legislature is aware of all the laws of the existing state of the law, okay, of the existing state of the law. And it enacts the law with the knowledge of the existing state of the law. So unless it explicitly alters that, we are not to assume that the legislature's intention was to alter that. It's an assumption from efficiency as well. The idea is that legislature knows what the existing state of the law is, okay, and it is mindful of that, and when a law is enacted, the same is enacted keeping in mind the existing state of the law, and it does not intend to alter it. That's the assumption. Now there is another assumption that is quite opposite to it, but let's look at what people have to say about this assumption. So Charles Wiener said in a general abridgment of law and equity that the general rule in exposition of all acts of parliament is this, that in all doubtful matters where the expression is in general terms, they are to receive such a construction as may be agreeable to the rules of common law in cases of that nature. For statutes are not presumed to make any alteration in the common law, further or otherwise than the act expressly declared. So that's the idea, that the legislature has the knowledge of the existing state of law, and if it intended to alter it, it will expressly, in clear terms, alter it. And if it doesn't, then the assumption would be that it didn't want to alter it. So that's the idea. But there is an assumption that is quite opposed to, this one. The other assumption is that, well, not even the judges know what is the existing state of the law. And they are the ones who deal with the law every day. And why should we assume that the legislature is mindful of that? Mindful of the existing state of the law? And if they are not, whatever they enact now is the one that we should consider, because the recent law is the one in which it has exercised its latest legislative intent. So that should supersede whatever existed before. So Justice Creighton said, it is impossible to know all the statutory law, not very possible to know all the common law. So statutory law which is there in itself is so difficult. How are we to assume that all the common law would also be known? Similarly, Lord Atkins in Evans versus Bartlam in this particular case, Lord Atkins said, "For my part, I am not prepared to accept the view that there is in law any presumption that anyone, even a judge, knows all the rules and orders of the Supreme Court. The fact is that there is not and never has been a presumption that everyone knows the law. There is the rule that ignorance of the law is not an excuse." Well, that's different though. A maxim of very different scope and application. But if the law is notoriously uncertain, we must not attribute to the Parliament prescience of what the law will ultimately be held to be. So yes, these are the two opposing views that you have. One that says that the legislature knows the existing state of the law, and hence the assumption would be that when there are interpretations possible, the one that is in conformity with the existing state is to be the one that is to be proceeded with. The other one says that, well, we should not start with that. Okay, it is not possible for the legislature to know all the law. So why should you start with that? But even then, the idea is that when two different interpretations are possible, the one, for example, when it comes to constitutionality of a legislation, okay, the one that is, if there are two interpretations, the one that is constitutional, the other one that is not constitutional, okay, then the one that is constitutional is the one that is to be preferred. Something of that sort is applicable even here, okay. So the assumption is that, well, the legislature did not intend to. So if it intended to, it will do so in clear terms. That's the idea. So anyway, that's it for today. We have few more presumptions, okay. As to jurisdiction, as to constitutionality, and those are the ones that I will discuss in the next class. So I think this should be enough for today.